And finally, we hit Roman numerals 7? 7. Roman numeral 7, which is other groups. We're talking about other groups that are discriminated against or have issues with civil rights and so forth. We're starting with homosexuality. The issue of homosexuality and homosexual rights, for the most part, doesn't really pick up till the 1980s because, as far as society was concerned, gay people didn't exist until the 1980s. No, really. While obviously homosexuals have existed, if you look at history and so forth, it was not something that was ever openly discussed in polite society. This is why, remember I talked about how we actually had a gay president, or we think we did, James Buchanan? Even in his history, no one ever actually comes out and says it, they just use lots of euphemisms. He was a confirmed bachelor with his best friend, that sort of a thing. Even people who are, very clearly, gay, Oscar Wilde, Paul Lynde, things like that, no one ever called them that because that wasn't something that you did. It isn't really until, again, the 1980s where you really see a push for organized homosexual recognition, I guess is the term I'm looking for. The moment that it's sort of seen as the big one, if you will, and this is something I probably should have put on your outline, and for some reason I forgot to. It's called the Stonewall Riots. The Stonewall Riots occurred in New York City. It basically involved police breaking up a gay nightclub, and there was brutal beatings. But the idea is that these were all people who, as they viewed it, was just like the civil rights movement because they were being abused for who they were. From a legal standpoint, homosexual behavior was banned in most states. The case, remember we talked about all the way back in Unit 5, where we talked about things like the ones that the Bowers v. Hardwick and Griswold v. Connecticut. The case of Lawrence v. Texas sort of takes it in a different direction. Lawrence v. Texas is the Supreme Court case that basically says that you cannot ban homosexual behavior. All right, Lawrence v. Texas basically is the one that says it struck down the ban on male homosexual sex in Texas. And so by extension, it said that all laws involving homosexuality basically could not be enforced. And so this is considered to be a huge step forward in that area. This was 2003, to give you an idea of how recent these changes are. And yet, when you talk about the idea of gay marriage and so forth, there was a big to-do about whether or not that was going to be acceptable or not. The U.S. government passed the Defense of Marriage Act because what had happened was several state Supreme Courts, starting in Massachusetts, ruled that you could not stop homosexuals from getting married on the grounds that marriage is a civil right, not a civil liberty, and so therefore the government could not, deny it to one group over another. And so as a result, they said you could not ban gay people from getting married. As more and more Supreme Courts ruled this way, the other states became nervous because remember, the full faith and credit clause says that if a state makes a decision or a legal decision or a legal document, other states have to recognize it. So if you get, for example, if two gay people got married in Massachusetts, North Carolina would have had to have accepted that because of the full faith and credit clause. The Defense of Marriage Act, or DOMA, was a law that precluded that. DOMA basically said that you did not have to acknowledge gay marriage if your state didn't allow it. Or didn't want to, frankly. But the Defense of Marriage Act didn't last that long. But again, it was there because many states then quickly took up voting and decided, whether or not they wanted gay marriage or not. North Carolina, for example, amended the Constitution and said that we didn't want gay marriage. In many, Proposition 8 was a law in California that would have allowed for homosexuals to marry. Actually, it repealed their gay marriage. But in any case, even in California, gay marriage by vote didn't work. And so as a result, again, a lot of people were very surprised by that, just like how we talked about with the English-only movements, how even in a very liberal area, it didn't quite work out. But all of this got sort of rendered moot with the case of Obergefell v. Hodge, I believe is the correct pronunciation. Let me spell that one for you, and again, why I didn't put this on the outline is beyond me. Spelled Obergefell. Obergefell. Obergefell v. Hodge, and Hodge is spelled like you'd think Hodges. In any case, Obergefell v. Hodges is the Supreme Court case that said gay marriage is legal throughout the country. Because, again, same argument. It's a civil right. You cannot deny civil right to somebody based on a factor in this case, their sexual preference. And so again, Obergefell-v. Hodges overturns the gay marriage ban, so it invalidates the Defense of Marriage Act, it invalidated all those states that changed their constitutions and so forth. So even though technically North Carolina Constitution says you can have gay marriage in North Carolina, remember that U.S. Constitution, U.S. Supreme Court beats state constitution, so as a result, North Carolina does actually have gay marriage. As for age, which is the next one on here, age is another thing that oftentimes we discriminate for and against. You all, again, have fewer rights than older people do. Children get discriminated against a lot more than old people do. In fact, of all the different groups that we're talking about, older people probably have the best chance of, again, doing well, simply because old people vote consistently. Young people don't. Because old people vote consistently, they are one of the more valuable groups when it comes to politics. And so as a result, this is part of the reason why you will never see a politician cutting Social Security, Medicare, because those things are what old people really, really want, because it affects them. And so if you vote against them, it's political suicide. But on the other hand, if I cut funding for public high schools, what are you guys going to do about it? You can't vote! And that's how it works. So younger people actually end up with sort of the short end of the stick here, whereas older Americans, because of their voting consistency, tend to get a bit more of an advantage when it comes to, again, to issues that they care about. In terms of disability, disability is considered to be a non-suspect classification because as long as it's a matter of practicality. In other words, again, we don't let blind people have driver's licenses. That's not discrimination. It's just an issue of practicality. But you have to allow for access for people with disabilities, as long as it's reasonable. This would be the Americans with Disabilities Act, or the ADA? Yes, the Americans with Disabilities Act. The Americans with Disabilities Act was a law that basically forces businesses, companies, etc., to allow for access for people with disabilities. This is why, for example, there has to be a certain number of handicapped parking spaces in front of businesses, why there have to be ramps, why there have to be, handicapped bathroom stalls, as long as the building's over a certain number of people, and so forth. The Americans with Disabilities Act is designed, again, to sort of to make these changes acceptable, or to more accessible, I should say. The catch with the ADA is that older buildings don't have to follow it. If it's grandfather claused and things like that. For example, if a building was built well before the Americans with Disabilities Act, they don't necessarily have to follow the same law. This is part of the reason why we have the cafeteria that we have. The gym was built prior to the Americans with Disabilities Act, so it is grandfather claused, meaning that you can't force us to make it handicapped accessible unless we refurbish it. If we built more onto the cafeteria or redid it, it would suddenly be a new building and we would have to make it ADA compliant, which means, among other things, probably an elevator. That's outside of the budget, so that's the reason why we haven't done it. This gets to the criticism of the ADA. The criticism of the ADA is that sometimes it's not practical, if you will. That sometimes it does not, by design, it does not take into account individual circumstances and so forth. And so as a result, you may be demanding things that only one person needs at the cost that is ruinous to a business. So that's the criticism of the ADA. Of course, the last thing under here, the idea of citizenship, discriminating and so forth. The citizenship status is also non-suspect because there's a very good reason why non-citizens have different rights. They're not citizens. The Constitution affects only citizens. Non-citizens do have some protections, cruel and unusual punishments, among other things. But for the most part, non-citizens do not get the same rights that citizens do. Whether that's acceptable or not is sort of up to the state still. They're still debating that. But that's the current sort of standard, if you will. That non-citizens don't have the same rights as citizens, and that's perfectly acceptable. So, I think that takes care of everything you could possibly need for Unit 9. Your test is on Thursday and Friday of this week. If you finish this well before Thursday or Friday, yay for you. You can go back and rewatch it or have a study hall or whatever else you need to do. If you are running out of time, then I guess come back at lunch. I don't know. Of course, at the end, so if you're seeing this, you've already finished it. I'm rambling. In any case, have fun. I'll see you later for Unit 10!